Kasongo ametuma mafisi hao wakiongozwa na fisi mkubwa zaidi mwenye meno zaidi anaitwa Mwengi Mutuse, Kawaya na Mbai. Hao ni watu maadui wa hii jamii.
We are not asking the court to take judicial notice, but we urge you to take notice. Not judicial notice, but notice that cases of computer misuse and abuse of the internet, especially by the political class,
waachilia consequence yako hiyo wakora na makanga wa Kasongo na umalaya yao wameleta hapa kwako. Lazima usukumane na nini. So I want to urge all the Wiper family and all the leaders, members of parliament, senators, governors and all the supporters. Tuko na maadui wameachiliwa. Hao ni makanga na hao ni mafisi. Kwa hivyo, kwa sababu Kasongo ametuma mafisi hao wakiongozwa na fisi mkubwa zaidi mwenye meno zaidi anaitwa Mwengi Mutuse, Kawaya na Mbai. Hao ni watu maadui wa hii jamii. Kwa hivyo nataka mtusaidie mara moja, and I want you to focus with those criminals because they are terrible people to our community. This all knowing or ought to have known that such communication is likely to cause, they say, honor Mwengi Mutuse fear of violence to you. Sure, not true? Not true to the first one.
Good afternoon, Your Honor.
Good afternoon.
May it please you, my name is Owiti. I appear together with Mr. Kiragu, Ms. Mudeu, and Ms. Atieno for the Republic.
Please, Your Honor. My name is Manjo. I do appear with Mr. Boniface Nyamu,
present, Your Honor,
who is with me here, and also Mr. Jackson Kala, who is at the, Mr. Jackson Kala.
Mr. Manzo,
Yes, Your Honor.
and you appear together with Mr.
Boniface
Okay.
Nyamu, and also Mr. Jackson Kala, who is not here, is at a Law Society conference, but I'm sure we'll follow this matter later. Your Honor, today we are not going to give Mr. Owiti a hard time. We'd rather do it at the trial. Therefore, we are praying for reasonable terms of bail, preferably cash bail. The accused person, Your Honor, is a nominated MCA of Makueni County by the Wiper Party. The complainant, Your Honor, named at the end of the charge sheet is a member of parliament for Kibwezi West, where the accused person is also vying as a member of parliament 2027. And therefore, what you've heard is really competition between the two. And that's why we are praying for reasonable terms of bail. I believe they want to come and do their politics here. As a member who is very experienced for many years, I had advised them not to do this. But since they want to come and do their politics here in court, we'll have our day in court, Your Honor. So we really pray for reasonable terms of bail. The accused person is not a flight kid. It's not a flight risk. And as an honorable member of the County Assembly, would be more than happy to come and defend himself against this.
Your Honor, four things. Number one, we are not opposed to bail. At least we agree with my colleagues on that fact. Number two, you've been asked at least twice to take judicial notice, twice. One, to take judicial notice that this is a politically motivated charge, and secondly, to take judicial notice that he was arrested in Makueni. Both of those instances are not circumstances where court can take judicial notice judicial notice is clearly defined under Section 60 of the Evidence Act. None of those two fall under that. So reject and ignore that call. Number three, we are glad that Council has clarified that there is no application on rejection of jurisdiction on account of place of arrest. We would have responded to the application. Because Council has defined his submissions as mitigating factors, we then urge you to also consider the aggravating factors. Number one, that there has been a surge in offences committed on the internet, contrary to the Computer Misuse and Cybercrimes Act 2018. We are not asking the court to take judicial notice, but we urge you to take notice. Not judicial notice, but notice that cases of computer misuse and abuse of the internet, especially by the political class, I can confidently talk about that because this case has been defined as a politically motivated charge by the defense. Because politicians have rampantly abused the internet, that should be an aggravating factor. Number two is that it is admitted by the defense that the accused person is a politician, a nominated MCA, if I got that right, which puts additional responsibility on him as a public officer. So that is the second aggravating factor. So that while the prosecution does not oppose bail, it is our view that the suggestion of free bond would be irresponsible and would not be this court defending the Constitution. So we agree with the defense that you defend the Constitution by not granting free bail. We also urge you that you consider those two aggravating factors to find that the reasonable bond terms in these circumstances would be higher than the 50,000 Kenya shillings that was granted by the police. Because that 50,000 Kenya shillings was to ensure that he appears before court. This court has a wider spectrum to consider, and we argue that the 50,000 Kenya shillings would not be reasonable in the circumstances. In conclusion, we urge you to exercise your discretion to grant reasonable bail and or bond terms in the circumstances of this case. I thank you, and I thank my learned seniors.
Just a brief rejoinder.
So I'm reminded by my colleague to add that the third aggravating factor is that this is a felony, not a misdemeanor.
Well, Your Honor, this section of the law has been challenged as unconstitutional and found so at the High Court.
Which section is that?
This particular section of 27, 1A, and found so at the High Court, but overturned at the Court of Appeal, but is currently proceeding at the Supreme Court. So as much as it was to be described as a felony, when Parliament made this law in 2018, and I sat and contributed through the proceedings as then a member of National Assembly representing Makueni, there was always a debate as to whether politicians are making this law to use it in times like this. No proceedings have been concluded, trials so far in this area. And therefore, as much as it is described as a felony, owing to those circumstances, we pray that that's not used against our client in granting, bail terms which the police otherwise had found reasonable, like 50,000. And he has brought himself here, Your Honor. and as a responsible politician. Now that the two politicians want to come and do their politics, is more than willing to do so. And I'm sure even if he were to be released on a personal bond, he will still avail himself. So that we could have this matter squared here, and the so-called fears, Your Honor, laid aside so that the two of them could participate in the honorable politics, and the people of Kibwezi West constituency will make a choice in 2027. So I agree with you, Your Honor.
To disabuse a notion which has been created by the prosecution, and if it is allowed to go disabused, it will be bad precedent. Your Honor, you have been told that if you grant free bond, it will be irresponsible of you. Your Honor, nothing can be further from the truth. Why do I submit so? I submit so because bond, cash bail, those things are discretionary. Those things are discretionary. The court has full jurisdiction and powers to grant terms as it deems fit. As it deems fit, as long as they fall within the law. So, if you deem it fit to grant free bond, if you deem it fit to grant 50,000, you will be within your powers and jurisdiction, and you will not be acting irresponsibly. You will actually be acting responsibly. So, having said that, I wish to leave it to court so that it can give us a verdict.
Having considered the submissions by both sides, the circumstances of the accused, I am satisfied that no compelling reason has been demonstrated to warrant denial of bail. The accused has a fixed place of abode, family and community ties, and has demonstrated compliance with previous police bond. The prosecution does not oppose his release. There is no evidence before the court that he is likely to abscond, interfere with witnesses, or otherwise obstruct the administration of justice. I am, however, not persuaded that this is an appropriate case for free bond. The offense with which the accused is charged is a serious offense carrying a substantial maximum penalty. The court must therefore impose reasonable conditions that sufficiently secure the accused's attendance while avoiding conditions that are punitive and disproportionate. The court considers that the following terms strike a balance that is appropriate between the accused person's right of liberty and the interest of justice. And the court therefore orders as follows: the accused person shall be released on the bond of 500,000 with a surety of a similar amount, and in the alternative, the accused may be released on a cash bail of 200,000 with two contact persons whose particulars shall be provided to the court.